Good morning. Time is now 9:32 a.m. This is the time and place for the regularly scheduled scheduling meeting of the Montana Public Service Commission. We are in the Bollinger Room here at the Public Service Commission. I will call this meeting of the commission to order. Would my colleagues please join me in reciting the Pledge of Allegiance? All right, thank you, colleagues. I would note for the record that Commissioner Pinocci, myself, Vice President Fielder, and Commissioner Bukacek are present in the Bollinger Room. Commissioner O'Donnell is excused today. All right, the Montana Public Service Commission welcomes public comment on any matter that is contained on today's agenda or any matter that's within the jurisdiction of the Montana Public Service Commission. Do we have any public commenters in the room? Public commenters within the room, seeing none. Do we have any public commenters online? Being informed we do not. No public comment this morning. There are two changes to the agenda this morning under the work sessions items. Matter number one, which is commission initiated to act on a budget change document. We are going to defer that matter to our next business meeting, which is set for September 19, 2023. And work session item number two, which is also a commission initiated matter, which is adoption of our FY24 budget, that will also be deferred to our business meeting of September 19th, 2023. That being stated, let's move into our action items. Action item. Vice President Fielder's throwing me off over here. So action item number one is approval of the commission minutes for the week of August 21st, 2023. Vice President Fielder.
Mr. President, I move approval of the minutes for the week of August 21st, 2023.
Is there a second? Look at you, just threw me off. We have a motion and second.
Starting out fun.
I know. All right. Is there any discussion or changes to the minutes as drafted for the week of August 21st, 2023? Seeing none, all those in favor of Vice President Fielder's motion to adopt the minutes for the week of August 21st, 2023, signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Saying no opposition, motion carries unanimously. The minutes are adopted. All right, let's move into our work session. As noted, work session items number 1 and 2 have been deferred to next Tuesday's business meeting. So we'll move right into work session item number 3, which is docket 2023.04.033. This is the complaint filed by Mr. Dale Robinson. We're here to act on a action to close the docket in this matter. Mr. Poco.
Good morning, President Brown, commissioners. As President Brown mentioned, before you today is a draft order closing docket. To give a bit of background, just to bring you back up to speed on where we're at with this docket, Dale Robinson filed a formal complaint against Northwestern, alleging that Northwestern's electric service tariff rule number 18 concerning level 1 small generator facility interconnection is unjust, outdated, and does not reflect current technology. Throughout that process, the commission has appointed a technical master to assist the commission with resolving this docket and also to file a report based on the parties' positions and analysis and recommendation. The commission now has received Dr. Donnelly's report. So in the draft order before you today is quite a bit of summary of the report. as well as the commission's next step to conclude this docket. I'll start with a brief summary of the report, just to let you know where Dr. Donnelly, what Dr. Donnelly decided. The report is also before you as well in full. So Dr. Donnelly in his report summarized the party's positions, analyzed the technical merits of the positions, and made certain recommendations to the commission. He summarized Mr. Robinson's position. Mr. Robinson requested that the tariff 18.6 be modified to allow most residential photovoltaic installations to be exempt from an external disconnect switch requirement. That was the thrust of the argument. Mr. Robinson complained that the tariff conflicts with the rule, Administrative Rule 38.5.8408 sub 6, and also conflicts with the National Electrical Safety Code and is unjust, outdated, and does not reflect changes in technology. So moving forward, he summarized Northwestern's position. Northwestern denied Mr. Robinson's claims and stated that the external disconnect switch, and I'll refer to that as EDS, going forward, is important to electrical safety programs and complies with the language of tariff 18.6 as currently written. Dr. Donnelly provided analysis to answer three particular questions: whether tariff 18.6 conflicts with the commission's administrative rule, whether tariff 18.6 conflicts with the National Electrical Safety Code, and whether tariff 18.6 is unjust, outdated, and does not reflect changes in technology. Ultimately, to answer the first question, Dr. Donnelly reviewed the rule and the tariff and concluded that a visible load break disconnect switch, which is in question here, does not conflict with the rule because a visible load break disconnect switch is an isolation device that falls underneath Montana Administrative Rule 38.5.8404. To answer the second question, Dr. Donnelly concluded that the tariff 18.6 does not conflict with NESC, specifically 444A3, due to the scope or due to where the work on a external disconnect switch is performed. The NESC applies to the utility side of premise services, and that's the National Electrical Safety Code, I believe. And he determined that the external disconnect switch is on the premise side, not the utility side. So thus the NESC is inapplicable. To answer the third question, which I'll go back behind you, all of. Third question was whether the tariff 18.6 is unjust, outdated, and does not reflect changes in technology. That was a majority of his analysis that he provided in his report. In doing so, he reviewed recent revisions to lots of electrical safety code standards. He looked at the usage of the EDS by Northwestern's workers, and he weighed the evidence. In there, he noted that there's a trend towards eliminating external disconnect switches, but 39 states still require EDS or allow the utility to decide if to use external disconnect switches. Primarily, he ultimately weighed that it's a safety matter and he wanted to err on the side of safety, and it's about the comfortability of using these systems. So to answer that question, he said that the use of the EDS is justified still at this point here in Montana. However, he did provide 5 recommendations within his report, and those can be found on page 9 of his report or on pages 4 through 5 of the draft order. Again, he stated that tariff 18.6 is consistent with Montana administrative rules, and he makes no recommendations to modify the tariff. He also concluded that the tariff or the provisions in tariff 18.6 do not fall within the scope of NESC and makes no recommendations to modify on that basis either. However, Dr. Donnelly did suggest that Northwestern should continue to improve and clarify worker safety training and procedures for premises with small generation facilities such as Mr. Robinson's. He recommended Northwestern periodically assess workers' experiences with EDS to determine if tariff 18.6 as written continues to be important for worker safety. Dr. Donnelly also suggested that the commission should monitor Northwestern's use of these external disconnect switches and should consider requesting documentation related to the incorporation of external disconnect switches. Finally, Dr. Donnelly did recognize a potential financial hardship of the EDS and Mr. Robinson's proposed PV installation. He recommended that Mr. Robinson submit a written request to Northwestern seeking an exception to tariff 18.6. On our end as the commission, we earlier in order 7900 allowed the parties to request a hearing on the merits within 7 days of the report. We have not received any request for a hearing. We also stated that if parties, the commission in its order stated that if the parties do not agree to the recommendations of the technical master, this dispute will be considered settled and we will close the docket. Neither party has requested the hearing, although neither party has explicitly stated whether they agree or disagree with the report. Since the 7 days have passed, the draft order states that the commission considers this docket concluded and this matter settled. In the order portion, we do take some of Dr. Donnelly's recommendations. First, within 14 days of the order, Dr. Donnelly is directed to file an itemized report of the total hours worked as the technical master in this docket and the amounts billed to both the parties. If you recall, in order 7900A, we approved the cost allocation that was submitted by Dr. Donnelly. So just compliance filing to make sure we have the correct amount of hours and amount billed to each of the parties. Secondly, if Mr. Robinson requests the waiver to his design of his PV installation, Northwestern is directed to provide a copy of its decision to commission staff for a review. And finally, in the order in paragraph 23, the commission directs Northwestern to implement Dr. Donnelly's recommendation to periodically assess experiences with external disconnect switches to determine whether tariff 18.6 continues to be an integral part of worker safety. And the order asks Northwestern to document its assessments and make them available to commission staff upon request. In sum, that concludes the draft order. I just wanted to make sure to go over all the merits of it. I ask that you approve the draft order and allow for any non-substantive changes as necessary.
All right. Is there a motion, Commissioner Bukacek?
Can I make a little discussion first? Okay.
You're.
Oh, I'm sorry.
You're
I'm
welcome.
out of order.
Yes, can you make the
I
motion?
make a motion to approve staff's recommendation. Excuse me.
And the staff recommendation is to approve the draft order closing as the final order of the commission. Is there a second?
I second the motion, Mr.
All
President.
right, Vice President Fielder has seconded. We have a motion second, Commissioner Bukacek.
Let me start over. To reiterate and clarify in consideration of the public's understanding of this, This docket is concluded because Order 7900 allowed the parties to request a hearing on the merits, and neither party requested a hearing within 7 days. Is that correct?
That's correct.
Then I say it was duly concluded, and I will be a yay vote.
Additional discussion? Vice President Fielder?
Thank you, Mr. President. I want to say that I feel that the report that we received was of excellent quality, and the staff summary and the draft order looks very good. I agree with the recommendations in it and appreciate the work that's gone into this.
Thank you, Vice President Fielder. Commissioner Pinochi?
Thank you, Mr. President. I want to talk about the switch minute. The idea of the switch is if we're generating electricity with rooftop solar and the power goes off, the switch is thrown so it doesn't backfeed the electricity to where a lineman may be working on a line and it, might electrocute him. Does that sound correct?
It sounds correct.
Okay. So a good question here is, if you go to Home Depot, you're going to find these generators for sale by Generac. The idea is you set them up at your home, and when the power goes off, natural gas feeds into the generator, automatically turns the system on, and you don't even know the power went off. Now, what amazes me here is that I hear complaints from the solar and wind industry trying to do rooftop solar or generate electricity, green energy, but I never hear the switch complaint when somebody's putting a Generac generator in. Now, the amount of Generac generators put in at homes by natural gas is so common that a lot of new construction of homes, this happens all the time. My neighbor's trying to talk me into one. Why is there never a complaint from the switches on natural gas Generac generators, but it always seems to be some sort of harassment with rooftop solar? Is any answer to that?
So for one, I will note that that question wasn't generally part of Dr. Donnelly's report. I will say there might be a difference between the two sources as well. I think there was some argument, but in this instance about differences between PV generating stations and motor generating sources. But however, I will say that was not explicitly addressed by Dr. Donnelly's report. He would be in much better position to answer that kind of question than myself, being an attorney and not, unfortunately, an electrical engineer. So I couldn't definitively give you a good answer to that.
Follow-up?
So the switch on a Generac generator, to be clear, when the Generac generator turns on, uses natural gas, that switch is just as important, because if we backfeed electricity into the system, it could knock a guy off the pole who's trying to repair the line that's down. And of course, during the time the line's down is when these generators turn on, because they're trying to supply energy to the home because it doesn't have it. The point that comes up is we just never hear the switch issue when it's generated by natural gas, but it is with rooftop solar. I'll look into that some more. Thank you.
Thank you, Commissioner Pinochi. Additional discussion? Additional discussion? I would just note for the record that in the commission's order of July 2023, we did notify the parties to this matter that they had the right within 7 days after the filing of Dr. Donnelly's written report to request a hearing on the merits of this matter. As noted, no hearing was requested, so I believe this motion is supportable, and I believe we met any obligation to notify the parties of what their rights were. Additional discussion? Seeing none, all those in favor of Commissioner Bukacek's motion to have the commission issue the draft order as the final order in this matter signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Poco. Okay, let's move to work session item number 4. This would be docket 2023.03.019 Highland Partners Holding LLC. This is a request for a special permit for continued use of Zaplock joints for the Bakken to WBI natural gas residue line. We're here to consider Highland special permit request. Mr. Gorski.
Good morning. Good morning, President Brown and commissioners. So as you just stated, this morning, I'm here to summarize and present a staff memo and a special permit request submitted by Highland Partners. Highland is asking that we approve a special permit to allow the continued use of Zaplock joints on their pipeline. So this pipeline, it's approximately 4 miles north of Sydney, Montana. It's a 8-inch diameter steel pipeline. It delivers natural gas from a processing plant to an interstate transmission line. It's about 9 miles in length. It was constructed in 2004, and it was built using a construction method or a joining method known as Zaplock. So Zaplock is a kind of a press fit way of joining pipe together. It's an alternative to welding in steel pipelines. So as I just said, it was constructed in 2004. In 2016, our federal pipeline safety partners, PHMSA, they wrote a formal interpretation that basically concluded the Zaplock connection method did not meet federal pipeline safety standards. So over a period of several years, we came together. We worked pretty closely with PHMSA. We worked closely with Highland Partners, the owner and operator of the pipeline, and we came up with a special permit as a way to sort of address these concerns that were written in PHMSA's interpretation. So the special permit includes 12 conditions that address potential risks associated with the Zaplock process. The conditions must be met by Highland and adopted by Highland, and in return, they're allowed to continue operating the pipeline. Just like to kind of emphasize that we've worked closely with Highland and the operator and PHMSA. Highland is aware of the 12 conditions. They've already commenced the work on some of the conditions, completed some of the conditions. And I guess it's been a long-term process over a couple period of years. We've sort of come together on these, and I don't think there's any surprises if the special permit's approved. So in conclusion, we would recommend that the commission accept as its final order the draft order and the special permit included in the reading materials for this week's business meeting with any necessary non-substantive changes. And I'm here for questions.
Ms. Fauski.
Nothing to add at this time. Thank you, Mr. President.
Thank you, Mr. Gorski. Is there a motion, Vice President Fielder?
Mr. President, I move that the commission issue the proposed order granting the special permit and allow staff to make appropriate non-substantive clerical edits if needed.
Is there a second?
A second.
All right, we have a motion and second. Discussion. Vice President Fielder.
Mr. President, a couple questions. First, I guess this one might be for Ms. Vikowski, but perhaps Mr. Torski. First of all, thank you for your good work on this. It looks good. It looks excellent, actually. The 60-day notice that has to go to PHMSA before the waiver's effective date. Are we clear that that's 60 just calendar days, or is it 60 business days? Do we know?
Mr. President, Vice President, it's my understanding it's 60 calendar days.
Okay, so we're going to, that if this is approved, it will go out this week then and meet that requirement without any trouble.
Mr. President, Vice President, yes, my intention is to have this process today, and then staff will get it out this week so that we'll have plenty of time before the effective date to allow the 60-day review by PHMSA.
Okay. I did a little math on the calendar myself, and so I figured if we had it out this week, even if they didn't count weekends, that we'd still make the deadline, the 60-day deadline, so we wouldn't throw any delays into this. Are there any of the conditions in this permit that are disputed by the applicant at all that you know of?
President Brown, Commissioner Fielder, No, not that I know of. I met with them a couple weeks ago in Sydney. We did some other inspection work, and we also discussed the 12 conditions and the work they've kind of done so far to meet those conditions. And no, the 12 conditions, they're a combination of, there's a couple they're reporting. So there's increased reporting requirements. There's a couple requirements that provide for increased inspection and survey work. So either they do a more sort of in-depth inspection or they do a more frequent inspection. And then there's several conditions that account for the possibility that they find something. So if they find X, they have to do Y. If they don't find X, they don't have to do Y, if that makes sense. But no, they're well aware of each condition. They're expecting to be able to comply with all those. They didn't dispute any of them.
Including operating at the max rate of, I think it was 800 PSI.
Yeah, no, they don't have a problem with that. The actual pipeline operates at about 450 PSI, 400 PSI. It's a condition, it comes out of a processing plant, which is a little bit different than the normal transmission type of pipelines we inspect, but just because of the way it's structured and the way it functions, that's the limiting pressure produced out of this processing plant. When it was tested, they tested it to a much higher pressure, and it was initially operated at a little bit higher pressure, but no, they don't have a problem with the 800 PSI.
Okay, thank you. And then just one other question for me, and this is, it just, they're in the packet that we have here before us, there's a draft special permit that's referred to in the staff memo. And then attached, there's a special permit, and it doesn't say draft in front of special permit, but it still has draft watermark on it. Is there any difference between those two documents in substance?
Thank you, Mr. President, Vice President Fielder. Substantively, no. You'll notice on the first page there, we've added some dates in there. That's the only difference between the draft permit that is attached to the staff memo and then the final permit that will be reviewed by PHMSA that's attached to the draft order.
Okay. Thank you very much. That's all I have, Mr. President.
Thank you, Vice President Fielder. Additional discussion or questions? Commissioner Pinochi?
Texas really likes to be the leader on all kinds of technology. And a good question is on this Zaplock process, is there any states that have said it's illegal due to safety concerns? And of course, a good question in Texas is, how do they feel about using this? They're trying to set standards that are higher and identify systems that have had a record of failure. A good question is there some state that said we're not using this Zaplock system, and why? Would be a question I'd like us to look into. Yeah.
President Brown, Commissioner Pinochi, to answer your question, has any state found the Zaplock process to be illegal? I don't know if I would characterize it that way. The state programs, as well as PHMSA, which regulates interstate pipelines, have determined that the Zaplock process may not meet federal pipeline safety standards. So several other states have addressed this. Texas is one of them. I believe Texas has issued a special permit similar to this one regarding a pipeline constructed with the Zaplock process. I don't know if I'd describe it as anybody saying it's illegal. I think they're saying this method in some ways is less tested than regulated pipelines, the way they're normally constructed with welded joints. The conditions people have developed are sort of a way to monitor things that are outside our, what we're familiar with a little bit more. So nobody said this is just plain legal. I mean, subject to check by an attorney, they might characterize it that way, but I think everybody's trying to work around what do you do with these pipelines when they are in a regulated jurisdiction, and how do you monitor them safely and kind of maintain the overall safety standards we assume for other regulated pipelines.
Follow up.
Follow.
If another state maybe didn't say the word illegal, but just said you're not going to approve them because of safety concerns, I'd sure want us to know about that before we made a decision. And I walked in to a gas pipeline company, looked at a valve and said that valve is illegal. They looked at me and said, "You're wrong." I said, "Make the phone call." And they said, "We'll clear them all out." So, it's happened. And I was responsible for clearing out all the gas valves in a supply place, just simply because I knew we had a failure. And, there's several different valves available. So if another state has got a safety concern and they're saying we're not going to allow it, I'd like us to know that. I think the other commissioners would want to know that. If there is no concern and all the states are saying, yep, we're comfortable with it, then I'm okay with it. That's all I have. Thank you.
Thank you, Commissioner Pinocci. Additional discussion? Additional discussion?
I just want to say I
Bukacek?
appreciate the fine work that you've done on this and the way that you answer our questions. It's a great job, and I'll be a yay vote.
Thank you, Commissioner Bukacek. Additional discussion? Seeing none, all those in favor of the Vice President's motion signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Seeing no opposition, motion carries. Thank you, Mr. Twersky. Ms. Wachowski. All right, let's move to work session item number 5, our final work session item of the day. This is docket 2023.05.038. This is a commission initiated matter. This relates to Class C deregulation rulemaking. We're here to consider amending and repealing commission rules referring to Class C motor carriers, which are no longer regulated per Senate Bill 33 in the 2023 Montana legislature. Ms. Webster, welcome. All right, colleagues, I move to approve the draft notice of proposed amendment or repeal and to authorize staff to make any non-substantive changes required for publication in the Montana Administrative Register and to file the same with the notice of Secretary of State. Is there a second? Commissioner Bukacek?
A second.
We have motion and second. Discussion? Colleagues, as you recall, during the 2023 legislative session, the commission requested the legislature pass and that the governor sign Senate Bill 33, which in substance repealed the Class C motor carriers statutory scheme from Montana law and from our jurisdiction, and therefore we no longer regulate Class C motor carriers. This matter before us is the consequence of enactment of that legislation. Obviously, we have a legal obligation to repeal any regulations that allowed us to otherwise regulate Class C motor carriers, and this was a matter that was brought forward at the request of the commission, and I appreciate the staff's quick turnaround on this matter. Additional discussion? Vice President Fielder?
Yes, Mr. President, just maybe more for public consumption. Can we get a brief summary of what was included under Class C? What types of carriers? I'll bet you Mr. Rosequist or someone else could.
Yes. Welcome. Is this the first time you presented? Hold on, make sure your microphone's on and please identify yourself.
I'm Gwen Knight and I'm one of the staff here.
Welcome, Gwen.
The Class C motor carrier was the household mover type companies that we regulated. Had to do with household moving of goods and things like that.
I think that's well stated. It repealed
Questions about that?
the authority for us to move household movers and goods and services.
Thank you. Appreciate that.
Thank you, Gwen. Additional discussion or questions? Additional discussion or questions? Seeing none, all those in favor of my motion to approve the notice of proposed amendment or repeal and authorize the Secretary of State to make, or staff to make changes and file with Secretary of State, signify by saying aye. Aye. All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you. All right. That concludes our work session items for the day. A couple announcements for the public. One, tomorrow, the commission will be participating in the Long Range Planning Interim Budget Committee Section F hearing. And at 4:15 tomorrow, we will be appearing before the Public Safety and Public Service Interim Budget Committee Section D of the legislature. Our next commission business meeting will be Tuesday, September 19th, 2023 at the regularly scheduled time, 9:30 a.m. Seeing no further business to come before the commission this morning, the time is now 10:09 a.m. and I adjourn today's meeting.